Good evening, everybody. It's Jonathan. I hope you are all doing well. I am back from my vacation. Had a very nice time. Went to the Florida Panhandle with some buddies of mine. We played tennis for 4 days straight, which was a bit of a challenge at times. And then after that, I had a friend of a longtime friend of mine got married in Washington, D.C. So drove back from Florida, hopped on a plane on Saturday morning with my wife, and we were in Washington, D.C. from Saturday through Monday. Got back about 6 o'clock on Monday, so a lot of traveling around. So I'm glad to be back. I'm kind of a homebody, so it was fun to do that. But I'm certainly glad to be back. So anyway, um, again, I hope everybody's doing well. So let's kind of hop right in the questions here. Jim has a question here that he's finally going to be talking to his attorney on November 20th. Hearing is the next day. Um, you know, ideally you'd be talking to your attorney a few days before the hearing, but okay, some people do it the day before. What are some of the things you'll be discussing? Looks like they're using the second IMA report and primary physician reports of other medical doctors. IMA, I think you're talking about maybe an independent medical exam. I think that really what I do, and I can't speak for your attorney, obviously, what I do when I'm preparing somebody for a hearing is we go through kind of the what actually happens. When you get on the phone, what the judge is going to say to you in terms of getting you sworn in, asking you to verify you're not recording the hearing, going through just, asking you if you're okay with the telephone or video hearing, um, asking your attorney if you discussed the issues, will you waive a formal reading of the statement, have you reviewed the record, just sort of the procedural kind of things. And then typically what most judges will ask is about your past work, and then they may ask you, why you feel you're disabled. So there's any number of questions. I've got several videos on what actually happens, but I think what I'll ask your attorney just to walk you through, if he or she knows the judge in question, just to walk you through what that judge is going to ask you. But generally speaking, there's some formalities. They're going to swear you in, ask you a couple of preliminary questions. Judges always ask about past work in the last 5 years, so you want to know what you did, the name of the employer, kind of what your job description was, and then be prepared to give an elevator speech about why you're disabled, why specifically you're not able to function reliably in a work environment. That's kind of and then I think that, what I would do is kind of go through the timeline, talk about, I'm a big believer in giving a narrative, telling a story, how you got from being functional and, playing sports and doing stuff with your family to the point where you're now applying for disability. What happened? Was there some sort of a injury? Was there an accident? Something like that. And so I think you want to have a narrative kind of set out. I think your attorney probably should work with you on not getting off track. Sometimes people tend to, they start blabbing and they start talking about stuff. When I was 16 years old, I fell off a truck. Well, that was when you were 16, but if you're now 53, you obviously got past that. So, you want to kind of stay away from that stuff. And I think you want to be prepared to give specifics if it's a physical case, how long you can sit, stand, walk, kneel, crouch, crawl, things like that. So those are some of the things that I talk about. The more specific, the better you can be in describing your functioning. And the final thing I would tell you is you always want to go with the idea that you hate the idea of pursuing disability. You're doing it because you have no choice, and that you want to make sure the judge understands that you are going to fight this every step of the way. You'd much rather be working, and you hate the idea of filing for disability. In other words, you don't want to be a person that feels entitled to disability. You want to be a fighter. So those are some of the things that I would talk about. And again, you can ask your attorney, look at some of the videos I've got, but that's kind of my thought. Okay, RD is having an SSA doctor, I guess a consultative, scheduled for med review this Saturday. Applied on October 2nd, so over a year ago. Back issues, depression, migraines, PTSD. What should I be on the lookout for as far as the consultative exam? I think that, there's, we talked about this before. There's a gentleman, Dave, oh boy, let me pull him up. Dr. Dave. He's on YouTube. Let's see if I can find consultative. I can't find his name. I'll find it. He is a medical doctor on YouTube who does consultative. He does consultative evaluations, and he talks about them a lot. And he's got a YouTube channel that kind of walks through it. So if somebody knows the name off the top of their head, just put it in the chat. But it's Dave something. I can't remember his last name. But he's got a really good YouTube channel. I'm not seeing it here. So if anybody knows what I'm talking about, please let me know. But anyway, the point is that, a consultative evaluation, if it's physical, my experience has been it doesn't really mean a whole lot. The mental health one's typically a little more important. I think you just want to be very truthful. Again, same thing as like when you're talking to a judge. Let the CE doctor know that you hate the idea of filing for disability. Give your best effort. You don't want the CE report to say that you were not giving your best effort. Be aware, really, this is really important, that they watch you walking in from the parking lot. They watch you walking in from the waiting room. They watch you, let's say you say that you have trouble getting off a chair, but if you don't have trouble getting off the exam table, that'll be in the report. If you walk with a limp in the exam room, but you didn't walk with a limp in the parking lot, then that's going to be noted. So you just want to be consistent. Realize most of the physical consultatives are not there to help you. These are doctors that do a lot of work for insurance companies that want to deny claims. So again, you just want something neutral out of that. A psych evaluation, you're typically going to get a little bit better results from, just because these are people in practice that are more reasonable, I think. So if you've got a physical medical review, if it's for physical back issues, things like that, they may take an X-ray, which doesn't really tell you about soft tissue. And if you have MRI reports, bring them. Give it to the doctor. So that's what I would tell you. Just don't expect this is going to make your case a winner. The best you can hope to do is just to sort of get a neutral report that doesn't really hurt you. Okay. Sky C. I'm 50 years old and just got my disabled update report. Forgot to date it. Leave my phone number. When the reports are going to cause. I don't think so. I think they've got, Social Security already has your information. If you wanted to send them a letter and just say, I forgot to put the date on it, but they'll mark it in the exhibit file. They'll mark the date it was received and the phone number they've already got. So I don't think it's going to be a problem. I would not worry about that. Okay, Trish, I had a great trip. Thank you, Trish. I did have a very nice time. It's just always good to get away and just kind of refresh the batteries. There's three other guys that I'm buddies with. We all played tennis for years together, and we go down there. One of them has a family condo, so it didn't cost us anything, which is kind of nice. And we just go down there. Our wives don't go. It's just the four of us, and we just eat pizza, eat some ice cream, out of the prying eyes of our wives, and play tennis and walk on the beach sometimes. It's actually just very relaxing. So, I did have a really nice time. And if you can, if you have an opportunity to get away, even for just a long weekend, that's cool, because it's really helpful. All right, Treston Milleris. Hey, everyone. Hello, Treston. Brooke, glad you had fun. I did. Thank you very much, Brooke. Cancer Baby. How important is the Social Security statement still in step 3, which is medical? Or they told me it's the longest step. As of the 28th, the statement said nothing. I mentioned this before. I don't think that the stages, the percentage complete that you're seeing online means anything at all. I think it's really just Social Security's way of, letting you think that they're doing something. It can go from 65% to 95% overnight. So I think, the adjudicators, I've never actually asked one. Maybe I'll ask somebody that, are they responsible for changing the percentage, or is it done automatically? But I wouldn't. Again, big picture in most states, every state's a little bit different, but an initial application is going to be, 8 to 12 months. The recon is going to be maybe 8 to 10 months. And to get a hearing is going to be, 5 to 7 months. That's kind of general. Some places a little bit faster, some places slower, but I wouldn't pay a lot of attention to what you see online as far as the progress of your case. Okay, St. Good question. How do your clients deal with incorrect medical records that you feel might hurt your case? You suggest a sworn affidavit to address the incorrect medical records. You can certainly do that. There's a form you can use. I think I should know this, statement of claimant or other person. I think 795. Uh, yes, SSA 795. I'll show you that. Um, and let me just share the screen so you can see it. And you can just look for this. Let's see, share screen. Okay, so this is SSA 795. You put your name there, you put your social security number, then you can make a statement. You would say something like, in reviewing my record, I see there are notes from Dr. Smith regarding my, lower back injury. Dr. Smith indicates that I have the capacity to stand and walk for 2 hours at a time. This is not correct. I do not. Or Dr. Smith saw me for 5 minutes and then his assistant did all the rest of the exam, whatever you want to say, but you'd put it on this. And then what I might do is, let me stop the sharing there. What I might do at a hearing is, in a pre-hearing brief, I might ask the judge, make the note to the judge that the claimant feels that this report is inaccurate for the following reasons. We would therefore ask you to give this less weight. The judge has the option of doing that or not doing that. But I think you put it on the record that you are challenging that. And if there are other records that are consistent with your point of view versus that doctor, then you could do that. You could certainly make note of that. If it's a consultative evaluation, I think most judges realize they're kind of useless. But yeah, I think you want to put into the record that you disagree with the doctor's conclusions or his assessment of you, and his thoughts about your functional capacity. Put that on the record and get it in the file. Again, you can't force the judge to disregard it, but you can certainly make it clear as to why you feel it should not be appropriate. And I've seen this done, and I've done it with consultative evaluations where I'll get a report back and it'll say that this individual, let's say, can walk heel to toe, is an example of a test. And the client will tell me, I didn't leave the exam table. I didn't walk heel to toe. I didn't do anything. The exam lasted 5 minutes. So, I might put I might get an affidavit or you don't really even need an affidavit, just the form 795. I'll draft something up for my client to sign that basically says, the exam was done on, May 30th, 2024. I was in the office for no more than 7 minutes. The doctor did not touch me. He did not ask me to do any, tests in terms of my physical capacity, walking, standing. Needless to say, his assessments about my capacity for these things is based on pure conjecture. And, what he's saying in this report that he did these tests is simply not true. And then I would take that, we'd file it, it would become part of your exhibit file. And then I would, in my pre-hearing brief, I would really discuss that and ask the judge to disregard it. That's how you deal with that, I think. Okay. Tony Snell. I'm pushing for one more year of work. I've had back surgery. I'm in constant pain, constantly fatigued. I'll be 52. How long do I wait to apply? Well, Tony, for the grid rules, the break point is age 50 and age 55. So if you're 52 or 53, it doesn't really matter if you're going to argue the grid rules. Generally speaking, the older you are, the better, because Social Security is is very, very, very conscious of the trust fund running out of money. So the fewer years that you'd be drawing disability, the better. I don't think the difference between 52, 51, 52, 53 makes a difference at all. I would tell you that if you can work, keep working, because you'll make obviously more money. You'll put more contributions to your Social Security. You'll be happier in the sense that you'll have more social interaction, more personal fulfillment. But if you get to, and I think also, if you get to a hearing, let's say you file an application, you get to a hearing, you can say to the judge, I thought about this back in 24, and I decided I was going to wait until 25. I was going to really push it as far as I could. And especially if your work record shows that you started missing time from work, or you started coming in, 3 days a week, you changed your work schedule, your work requirements, that would be evidence to show that you tried to keep working but were not able to do so. So I think if you can, build a paper trail showing that you, worked to the extent that you possibly could, that again, you changed your job, what they ask, that you ask your employer to change what you did, and that you're fighting it every step of the way. And I think that those things are very, very helpful. So that's what I would tell you. But the difference between 52 and 53 it's not going to change anything. Okay, Dave Foster, J. Dave Foster. Thank you, Kay Wolf, is the doctor on YouTube, and Dave has a channel about what he does as a consultative evaluator and the tests he runs and what convinces him in terms of credibility. I would say that Dave is he does it the right way. He's a very sincere, capable, compassionate doctor who wants to do the right thing. Most consultative doctors are not like Dave Foster. So, I think it's helpful to know what he thinks, but the exam that you're going to get is not going to be the one that you would get from Dave Foster. But I think, again, it's a good way to kind of understand what they're looking for and what they're going to do. But I think, again, my experience has been that the physical consultative evaluations are typically just, done by insurance company doctors that are used to, deny claims, and they're usually not very thorough, and they don't carry a lot of weight most of the time. Not that a judge wouldn't use it to deny a case, but, I think that, St. Louis Grant, Dave Foster, yeah. So that's just my opinion. That's just what I take. Rick Torres, thank you very much, Rick. I appreciate it. It's very thoughtful of you. Again, this will go towards, I don't know, I don't drink coffee, but maybe a hot chocolate. I just don't like coffee. It's not that I have any reason not to drink it. Maybe a hot chocolate, or maybe you can go to a sandwich shop at some point. But thank you very much. I really appreciate that. Very nice of you. Vince, how are you doing, Vince? One of my clients. How are you doing? Lucy, I've been approved before, after age 18. I'd like to apply again when my past cases help me in the present. I'm sensing what you're asking me, Lucy, is that you were approved as a child, and then you maybe went back to work. I don't know. A couple of things to think about here. First of all, the fact that you were approved before, I think it does help. It does show that you were found to be disabled. If you did go back to work, that's a good thing. That shows that you are motivated to go back to work. Now, the one thing you got to be careful about, you don't say how old you are. Do you have enough credits for disability in your own earnings record, or are you going to be SSI? Obviously, if you have your own credits, that would be good. The other thing to think about would be that maybe you can pursue disability as a disabled adult child. If you became disabled prior to age 8, I think it's prior to age 18, and someone else in your family, a person maybe who claims she was a dependent parent or whatever, is getting Social Security, you could pursue it as a disabled adult child. So that may be something to look into. I don't see a lot of those cases, so I'm probably not the best person to ask about disabled adult child benefits, but I think that might be something to look into. Again, but I do think that the fact that you were approved before will carry some weight, because obviously Social Security, had found that you were disabled before, and unless your condition has dramatically improved, it makes sense you'd be, there's a good likelihood you're disabled now, and especially if you tried to work but couldn't do it. Official payday, got it. I was told I was fully favorable to SSI North Carolina to ask for bank information. How long would you receive payment? If it's SSI, now, are you sure it's SSI or is it SSDI, or you're not sure? SSI is a means-tested program. So if you got approved medically, then the SSI office has to do an income and resource interview. That can take 4 to 6 to 8 weeks. If it's SSDI, where you're basically on your own earnings record, the only thing you need to confirm is you have not worked since the onset date. There's no substantial gainful activity level work since onset. You might be looking at 2 weeks. So if it's really SSI, I would tell you it may be 4, 6, 8 weeks. If it's SSDI, maybe 2 to 3 weeks. And this is just another point I want to emphasize. A lot of people will email me and they say, I want to apply for SSI. They hear SSI, it's kind of like Kleenex or Xerox. It's kind of a generic term. But SSI is a very specific kind of disability. It's for people who do not have earnings records that would give them enough credits to pursue SSDI disability. And so SSI is much less robust in that There's offsets. If you have a spouse who's working, that probably offsets your SSI. If you're getting support from family and friends, that can reduce or completely offset your SSI. If you have savings assets more than $2,000, offsets your SSI, reduces or eliminates it. If you have, you can have certain assets like a house or a car, but if you have other personal property, that can offset it. So if you have any kind of earnings, that reduces it. A lot of things that make SSI much less desirable. So when you talk about disability and you're mentioning using SSI, make sure you really mean SSI, supplemental security income, because you don't have an earnings record. And again, if you're not sure about the earnings record, go to ssa.gov/myaccount, get your My Social Security statement. It will tell you whether you have enough credits. Generally speaking, and there are exceptions because for younger people, but if you've worked for 5 out of the last 10 years, so if let's say I'm looking at a case and somebody stopped working in 2021, they will be insured through 2027. If they stop working in 2016, they'll be insured through 2021. And that means that if I took that case, I would have to prove my client became disabled before their insurance credits ran out. Again, in that case, example, 2021. I have a case, I was talking to my client today, and we're talking about amending the onset date, which I'll be happy to chat with you about if you want to know. And her date last insured for Title II disability is December 31 of 2023. And so I have to prove she became disabled before December 31 of 2023. If the judge found her disabled in February of 24, no go, no luck. She's SSI only. In fact, I have a case right now that I got an approval on. I won, but the approval, the onset date the judge used in making what they call a partially favorable decision was my client's 50th birthday, again, the grid rules, and that was after her date last insured. So she's SSI only and she's got assets, so she's going to get nothing. So, we're looking at possibly appealing that, but it's going to be an uphill battle. So, okay. Just started dialysis is slam dunk. There ain't no such thing as a slam dunk in Social Security, but if you're on dialysis, that is a listing level impairment. You might want to look at the listings for kidney dialysis, and it's generally a situation where you're likely to be approved, but no slam dunks. I've seen more cases than I'd like to that clearly should have been approved early that were not. It also depends on your age. I mean, if you're 42, okay, and you started dialysis, it sounds like you should be approved, but you may not be. If you're 56, much more likely you're going to get approved early. But generally speaking, you're on dialysis, you're going to get approved. More so patient notes written by the doctor or nurse. In what context? I think that in terms of inaccurate information, if the notes are inaccurate in the sense that they talk about something you did not say, or they report something that is not accurate, you can certainly, when you complete the 795, you want to be specific as to what is inaccurate about that. And again, you have situations sometimes where a nurse will be in the let's say nurse practitioner or a physician's assistant will be in the exam room. The doctor signs off on it, but the doctor never saw you. So I think that would be relevant to say too, that the person who filled these things out was just it was not the doctor, and it was inaccurate. These are not things that I said or did. So that's what I would say. RD is a 54-year-old vet. Let's see what RD. Okay, he's the one who had the review for medical. Yeah, I mean, I think that that helps in the sense that you are in grid rule territory, and the grid rules at 54, you have to basically show that you're limited to sedentary work. So even if you could do sedentary work, you are still disabled. At 55, even if you could do light work. So realize that what the grid rules do is they change the definition of disability. At 50 to 54 and 12 months or 11.9 months, even if you're found that you can do sedentary work, sit-down work, which is standing 2 hours, lifting 5 pounds frequently, 10 pounds on occasion, you are still disabled. So it's a really helpful tool. But 54 makes it easier. But don't expect the consultative doctor to, necessarily limit you to sedentary. If he does or she does, that's great. But he may limit you to light, in which case you need to get other records to limit you to sedentary. Although I have a case coming up. It's actually tomorrow. Come to think of tomorrow, Friday. I've got one tomorrow, one Friday, where the consultative doctor limited my client to kind of a modified sedentary. But again, even if you could do that, I think she grids out. So I'm making a grid rule argument. This is a lady who there's no past relevant work in the last 5 years. She worked a long career, but not in the last 5 years. A lot of part-time work, but nothing rising to the level of substantial gainful activity. So I argue she's going to meet the grid, no past relevant work, limited to sedentary, and no transferable skills because there's no past work. So I think we're going to grid out. Yvette's MRI showing bone spurs in the lower back, labral tears in hips, orthodontic surgery due to age. I'm in A. That you got me. Here we go. Okay. It causes pain. Okay. Again, this kind of reminds me of my case tomorrow. I have a client who's 52 now, 53, maybe 54 even. But we're going to argue the sedentary grid. She is not a surgical candidate. Basically, she has a lot of back issues, bulging discs, bunch of things, but there's no surgical note. And she's on long-term pain management. She's got the physical therapy, the epidurals, the TENS unit, all that stuff. So, is there do some judges see a surgical recommendation as kind of evidence of a more severe impairment? Absolutely. But there are many situations where surgery is not going to solve the problem. It's not necessarily a disc problem. It's, maybe there's no surgery that would be safe to do. It just simply could be, swelling. It could be, any number of other things, but it's not surgical in nature, or it's not to the point where it's surgical in nature. So the answer to your question is, if you have evidence of pain, there is something there that would justify or support an allegation of pain, even if you're not a surgical candidate. Social Security law says that your subjective complaints need to be considered by the judge. Now, if you have an MRI that shows, mild, degenerative disc disease with, no nerve impingement, there's no stenosis, anything like that, that's not really consistent with a high level of pain. But if you have, moderate stenosis, which is the narrowing of the space in the disc, the bony disc, or you have mild to moderate, either stenosis or nerve impingement, that may be enough. So, the judge has got to consider your subjective complaints, and if the doctor agrees that your objective test is consistent with your subjective complaints, then you should be okay. But again, the MRIs are going to really, that's probably the most important test for back cases, because it's going to really show what's going on. And, again, you may see, degenerative disc disease, but everybody's got that. So it's got to be something more than just generally degenerative disc disease. So anyway, but I hope that answers your question. So yes, it's possible to win even if you're not surgical. You just need to have something there that's consistent with the level of pain you're experiencing. Kevin, sorry for sharing. Kevin, you are welcome anytime. Got my hearing results and hey, fully favorable. Great. 18-month process. Still a long way to get. Okay, well, that's awesome. That's I know it's a long time, and it's kind of a bittersweet victory because I'm sure there's a lot of suffering in that 18 months, but it's better than not getting a favorable decision. So that's good. I'm very, very happy to hear that. Vincent, do adjudicators deliberately mislead an applicant about how strong a case they have and likely to be approved soon? I don't think they deliberately do so. I think that most adjudicators are more focused on getting their work done. I've had several conversations with adjudicators, claims specialists, over the last 5-6 months, and most of them, really want to do a good job, but they're kind of hamstrung in some respects by what their job allows them to do. They may believe you're disabled, but they don't have the evidence they need to push it through. And, having had adjudicators as employees before, I had one, Stephanie was a woman named Stephanie years ago, was an adjudicator that came to work for me. And she's like, yeah, we will go to bat for a claim that we really believe in. So, yeah, they'll do that, but I don't think they mislead you. I think sometimes, do they want to get you off the phone sometimes? Yeah. Are they kind of vague about what they say? Yeah, sometimes. But I don't think it's, are there some out there that are just, not very nice people? Sure. But mostly I think they want to do a good job, and they're just working really hard under very, very difficult circumstances. So I don't blame the adjudicators for being overworked. I think Social Security, it's Congress. Really, it all comes down to Congress. I mean, we've got a commissioner, I think, really is trying to do the right thing. We have, adjudicators and Social Security people that I think want to do a good job, but they don't have enough time, they don't have enough personnel to do it. And it's also a difficult place to work. And so, there's a, report that comes out about federal workplaces, and Social Security always ends up last. And so some of the more experienced people get poached away. The VA is known for poaching them away. So, many times the staff that Social Security has are fairly new. They're not necessarily all well trained, and, there's a lot of turnover. So, that's the bigger problem. It's just the lack of resources. But I don't think, Vince, that they purposely look to find a way to screw with you. That's not been my experience. Lulu's after party. I have an appointment coming with the medical doctor. I'm on steps 3 to 4, morbidly obese, arthritis, knees, high blood pressure, to talk to the judge. Maybe. I mean, I think that at 57, arthritis in the knees, I think you could probably make a pretty good argument you're going to be limited to, sedentary, or certainly no more than light work. So the grid, 202.06, look at that one. Will the adjudicator catch it? Maybe. Do you have MRI reports in there? How clear is it? Is there any question about transferability of skills? If the adjudicator can't, put a neat bow on it, it's really straightforward. They just will deny it and go in front of the judge. I think a judge is going to look at that and say, yeah, you probably would be, assuming that there's some evidence in MRI or something that shows, just that supports your arguments regarding the knees and maybe some back pain. Obesity contributes to those things. Obesity is no longer a listing level condition. It was a number of years ago, but it's a factor. The high blood pressure, again, what does that mean? You have headaches. You don't win on a diagnosis. So arthritis in the knees, is it mild arthritis? Is it moderate to severe arthritis? Does it limit your walking? So the real key here would be to show that you can't stand or walk for 6 hours a day, so you can meet the grids. And so you have a doctor who's willing to say that. And then if you have to talk to the judge, talk to the judge. Yeah, I think that, if the medical evidence supports you, what you're telling me here is a pretty good profile, I think. And I hope you have good luck with it. Carrie Berry, finally had an MRI and CT scans, I think you meant, showed lung scarring, among other things. Also for 55 will get approved. I do have 40 credits. Well, again, having the lung scarring, what does that mean as a practical matter? Do you have problems breathing? Do you have problems with pulmonary irritants, dust, fumes, gases, heat and cold? So, what does it mean? Having scarred lungs, if it's very mild, a hypothetical a judge might ask would be, this individual needs to avoid, let's say is limited to sedentary work, needs to avoid extremes of temperature, pulmonary irritants like dust, fumes, and gases. Are there jobs out there? Well, there are jobs out there that do not involve pulmonary irritants. So that, you're not going to win if it's mild. If it's severe to the point where you have to use an inhaler, or you get out of breath, or you passed out, different story. If you have pain there, if you have episodes where, periodically for a reason or no reason, you need to have oxygen, different story. So it just depends on the severity of your lung issue, as well as the practical implications of that, what does it mean in terms of your functioning? So again, you don't win because you have scarred lungs. You win because your scarred lungs limit you from, physical activity or walking more than 15 feet, or that you have coughing spells, or that you are, that you cannot be around perfume. Let's say even mild pulmonary irritants. That's how you win. Lucy was approved prior to 18, and after 18 to 20 on SSI, 39 mental situation. Again, did you work? That's really the question here. If you got an SSI before and things have not really changed, if you have not worked, you could try to get an SSI again. If you have worked, then you have an earnings record, you can maybe get an SSDI, which again, I believe is a much more robust program. Sorry about that. Yes, congratulations, Kevin. I agree that Kevin got a favorable decision after 18 months. I think this is one we already talked about there. Lucy, my pleasure, Lucy. Jackie Padilla, 54 years old, working 27 years. And that's actually very helpful, having a long, consistent work history. That's really good. Judges like that, because a person like you is not going to pursue disability unless you really have no other choice. Been in psychiatric and psychotherapy for 6 years, diagnosed with major depression, psychosis, general anxiety, to have a chance of getting SSDI. Well, you certainly always have a chance. I would say with mental health cases, what I find works is, indicia of severity. In a depression case, that means, inpatient hospitalizations, suicide attempts. It means, not all these things, some of these things. It means that your doctor has tried multiple medications and has to keep increasing the dosage or changing the medications because you're treatment resistant. The psychosis, how often does it happen where you lose touch with reality? What triggers it? Is it easily treatable? Is it something that happens, on a weekly basis with minor stress? And if you have a doctor that will say, that Jackie, with even minor stress, just a, let's say, I don't know, just requirement to fill out a form for some reason, or, a relative makes her very stressed out, that she could slip into psychosis, because every job has stress. So if your doctor is willing to say that even minor stress could trigger a bout of psychosis, and this happens every week, that's going to make your case that much stronger. Remember, the issue in a disability case is, would you be a reliable worker? You've worked for 27 years. What is changing? What is making you less reliable? Obviously, you were able to work through these issues before. Now things are getting worse. What is happening? What are the practical issues? And I think in mental health cases, it's really, really helpful, really important, in my opinion, have your doctor behind you to fill out a functional capacity form, let's say a mental health functional capacity form. And Jen had given me, she'd copied from some of the other ones. Let me get you, I'm going to put this in here. Oops. There's some free functional capacity forms. I'm going to put these in the comments here. So if you want to, take one of these to your doctor, that would be certainly helpful. But again, I think that, you just, big picture is, if you have significant mental health problems, that can be a grounds for finding you disabled, but you have to have really good evidence, I think. Rodney, I put Rodney, if you all may remember, Rodney was one of our clients, and we got a favorable decision from a very difficult judge. Another attorney in my office did the case, and I was thrilled that she got a favorable decision. And Rodney wanted to get a copy of the audio, so he got the CD, and they used something called OGG format. So it's an audio in OGG. I don't even know what that stands for. And it's, there are readers, you can get OGG readers, and I've got one because I have to listen to these hearings sometimes. But Rodney wanted me to convert it to an MP3. And so he sent me the CD several months ago, and I've had it sitting here. And so finally he emailed me today. It's like, what's the status? I'm like, okay. So I pulled it. It took me literally 5 minutes. It was an easy thing to do. And I sent him an MP3 file. So I'm glad, I'm sorry, Rodney, it took so long, but I'm glad you've got that. And you'd asked me if you can come by the office and pick up the CD. And yes, absolutely. I should try to I've got a hearing tomorrow, but I'll probably get by there either tomorrow or Friday, and I'll leave the CD. So if you come by, somebody will give it to you. Um, Thanks. Yeah, I got a haircut. Actually, right. Thanks for the hair. Nice haircut. Yeah, I before I went on vacation because I knew I was going to this wedding, I had to get a haircut, and I have I don't know if you ever heard of this. I have like a cowlicks in my hair, um, and of course, unlike many of my friends, I still have hair, which is kind of cool. But I have these cowlicks, so my hair kind of goes the wrong way a couple of ways. My wife would tell you that's not just my hair that goes, you know. But anyway, um, any case, there's like I found my wife's hairdresser. My wife has red curly hair, so she has a hairdresser that does her hair. But this lady's in Buckhead, which is about, it's sort of not quite downtown Atlanta, but it's a 35 minute, 35 minute drive, but it's in Buckhead. So I have to go down there. So it's going to take me a little while to get down there. So I texted her, I said, I need an appointment, come in, Thursday. So I show up on Thursday. She didn't put it on her calendar, so she couldn't take me. So she normally doesn't work on Mondays. So last Monday, before the week before I left for my little vacation, she met me there on her day off and cut my hair. So she manages to keep it, looking like halfway normal. I also, because I part my hair against the what they call it, a crown, just the way I've always done it. So she's able to make it work. So, to the extent that, it looks halfway decent, Naomi, she's the one who does it. So, but thank you for noticing my haircut. Okay. You probably don't, most people probably don't care at all about my haircut, but you asked me, so I'm telling you. Christina, hello, Christina, one of my loyal listeners. And she always tells her, please do not forget to like, comment, share, and subscribe. And I've got the little crawl at the bottom if you want to leave me a review. That would be great. I really appreciate it. Mr. YOLO, you only live once. Okay. Well, you know what? That is, I think that's a good lesson to learn, because you only live once. So enjoy your life. Absolutely. 100% PNT, permanent total disabled vet. Recently received a letter from SSA saying my SSDI benefits will be terminated because I was SGA 1 year prior to being disabled. I was on a ticket to work that year. Yeah, that's an issue. You can appeal that, and you should appeal that. That is a little bit beyond what I do. I don't really deal with ticket to work issues. I wonder if Greg Brinkley might be of help to you. Let me give you some information about I'm going to put this in the comments here about how to reach Greg, but he could probably what would be a good start to help you. And Greg he's been on the live stream before. He's a friend of mine, and he used to work for Social Security and kind of knows some of the ins and outs of some of these unusual things. This might be a situation, Mr. YOLO, that you want to get your U.S. Senator involved in, because if you were in a ticket to work and they're saying that you worked and they're cutting you off because they're saying you were SGA but you were ticket to work, that something doesn't smell right there. Okay. Jamie, how long is a reconsideration? Been 10 months, haven't got my letter, should go to the office. Call SS, not SSI, call SSA. We want to be specific about these things, not SSI, SSA. 10 months is about average, so you should be hearing something soon, but there's no reason not to call them. But 10, 12 months, if you're in Texas or Florida, you could be looking at 15 months. But 10 months is kind of, you're sort of in that, that ballpark there. Thank you, Christina. Appreciate that. Christina has always been a great supporter of ours, and I really appreciate it. Official payday. Okay. That's a good sign. So official payday got, heard they got I'm assuming it's a he or she, got a notice from Social Security or a call that you're fully favorable. Then they called to ask about income and living arrangements, ask about if you wanted to direct deposit, bank information. That's a good sign. That means they're processing it. Something's happening. So that means you'll see your money, sooner rather than later. So, yeah, that would be great. And yes, Christina, please leave if you like it. I hope that you find this useful. I hope you find my videos useful. Love 5-star reviews. If you think there's something I'm doing I could do better, I'd rather you email me as opposed to leaving a bad review. But I want the reviews to be legitimate and sincere, because I don't pay for reviews. But I want people that have legitimately and truthfully been helped. And so those are the people I want the reviews from. So yeah, that'd be great. Um, oh, thanks, Kelly. I appreciate that. Yes, thank you. I really appreciate that. I don't ever, I mentioned sometimes people that are my clients, if they mention that before, or they'll mention it like this, I don't ever talk about my clients and their cases by name, just privacy issues. But if someone says, yes, I'm a satisfied client, then Kelly, thanks. Yes, I appreciate that. It's important, we got to be, as lawyers, we have to be very careful about confidences. So I'm very sensitive to that. And Jen, by the way, is my paralegal. She usually pops on at some point during this. She's got young kids, so she's doing school activities sometimes, so she doesn't always make it. But Jen's very, very diligent, works really hard. Scott Hausman, I'm 56, have Meniere's disease, vertigo, and tinnitus. Have a chance. I've won some vertigo cases because that is, if it's constant, it can make it very, very hard to function. You're just going to need, you know, medical support. You're going to need support that you've been evaluated. There are tests that can be done for vertigo. There are people who do, I forget the term for it. I'm blanking right now, but I'm drawing a total blank on it. But basically, there are terms or there are physicians and there are therapists who deal with vertigo and with Meniere's disease. And so, yeah, if you have good good support from a therapist or a doctor, then I think you've got a chance. I've won those cases. I've also had unfavorables if the vertigo is not well documented, if there's no evidence of it through multiple tests. So this is one of those cases, one of those diseases or conditions where you've got to go to the doctor and have have support. But yeah, you can definitely do it. Um, ooh, you've got a $283,000 overpayment. Well, okay, so this you're the one who was talking about the ticket to work and all that. Couple thoughts. One is there is a form you can fill out to ask for a waiver of overpayment or reduction in it. I would definitely do that. Look up, request for waiver of overpayment, Social Security. Other thing you can do, and you might look at as unpleasant as it may sound, is file bankruptcy on it. I used to do a lot of bankruptcy work. I don't really do much of it anymore because I'm so busy with Social Security, but you can bankrupt the Social Security overpayment. It just goes away. Now you've got to qualify, if you're in Chapter 7, you've got to qualify for Chapter 7. If you're in a 13, then you may end up paying some of it back. But if you can qualify for a Chapter 7, just wipe it all out, then that may be the way to go. So that would be something to look at, or ask for a waiver. And if you get denied in the waiver, you can ask for a hearing and take it to a judge and say this is not fair, and explain why. So yeah, there are a couple of things you can do. RD, you're welcome very much. You're welcome very much. Okay, I think we've already seen that one. I live with a relative who asks the problem of food, but I work. Okay, oh, there's Jen there. Okay. Yeah, again, if you're working under SGA, shouldn't be an issue. But, I think you're just going to have to go through the process. And, depending on whether you're SSA or SSDI or SSI, it will make a difference as to what the review is. But it sounds like you're well on your way to getting paid. Jen is saying, good evening, everybody. And Jen, good evening to you. Hope you're doing well. Thunda 10453. I had a mental and physical exam on August 24. I've told to get an answer 4 to 6 weeks. Didn't get an answer. Nothing in Social Security happens very quickly. If you have an attorney, your attorney can get you copies of the exam reports. That might be some interesting reading. It's just nothing happens quickly. So, don't panic. And 4 to 6 weeks may really mean 8 to 12 weeks, but that's just because they're so backlogged. And this is just the way it is. How much? If you're SSDI, you can have unlimited amount. There's no limit. SSI, you're limited to, I think it's $2,000 of assets, hard assets like cash. So SSDI, there's no limit. Okay, so this is YOLO. We talked about the overpayment, and like I said, I think it's one of these situations where you can either ask for a waiver or or you can ask for, let's see, I'm just looking here, or you can ask for a hearing and argue to the judge that this is not done correctly. Okay, freeze case evaluation, that's how to contact me. Great heads of hair, okay. Thank you, No Sky Daddy. Any reward for writing up somebody scamming SSDI 50,000 a year? No reward. I'm not aware of any reward. I would just say this. It can be tempting to, and if somebody is truly scamming Social Security, it benefits everybody to have that stopped. I would just tell you that I've seen situations where people don't really know the full story. Now, again, if you know for certain a person is on disability and earning under the table 50,000 a year, if they're getting a paycheck, that's being reported to Social Security. So that would seem unlikely, but you can contact the Office of the Inspector General. Just look that up and you can report it if you feel it's legitimate. But just realize you're messing with somebody's life and you want to be real, real certain. But there's no reward to you, if that's what you're asking. Okay, that's great. This is Greg Brinkley. Okay. I think I put that in there myself there. Okay. And just brinkley.org. That's his website. Greg, that's his email address, by the way. Okay. YOLO, appreciate it. Yeah, I appreciate you. Hey, Johnny. I was not here last week because I was on kind of a mini vacation, so you did not miss anything. Okay. Rodney says, even though as a difficult judge, I've listened to the hearing, actually feeling the perspective was sympathetic. Yeah, it's interesting. And the judge you had is notorious for being one of the more unpleasant judges that we deal with. Now I didn't try the case. Susan Bloom in my office tried the case. And it was in-person hearing. So maybe this judge is a little more, open to people when they're in person. Maybe he thought Susan did a particularly good job. Maybe he thought you had a really good case. I don't know. But I did hear a little bit of that. Yeah, he did seem a lot friendlier than he's ever been to me and to anybody else that I know. So, yeah, I mean, you got, look, don't look a gift horse in the mouth. Good deal, Rodney. You worked out great. Getting SSI, no CR 57. Dennis, I don't necessarily think that Social Security is really looking at people over 55 to do continuing reviews on. You're getting close to retirement. You're not they're not the person they're trying to go after. They want to go after the 35-year-old. They're looking after the person who was approved at 25 and now is 35. And, should that person have gotten better? That's who they go after, not really the 57-year-olds, I think. Oh, great. Okay, Kevin. Okay, so Lisa, I keep meaning to get, I've asked Lisa to come on. She's got some family issues she's kind of dealing with on Wednesday nights, so she's not been able to do so, but I'll ask her again. Yeah, I when I get really busy, I refer out. There's a couple of people I refer to. Lisa Palmer in Oklahoma is one of them. Lisa, she and I have talked a number of times. We brainstorm about stuff. She's great. She's a really good attorney, and I have no qualms or hesitation at all about referring anybody to her. And so I'm glad that it worked out for you. Okay, I think Roger, you said that listening to the CD that he was actually pretty nice. All right, Breach 66. Hello from Pennsylvania. Hello, Breach. Had a phone hearing. Appreciate your experience. Videos, bipolar and peripheral neuropathy. Yeah, I mean, I think both those conditions, if they're significant, they cause limitations in your capacity to work, they can be support a winning case. So absolutely. But I'm glad you found this helpful. All right, and No Sky put up here the waiver for overpayment, the form to fill out. It's the 632. Now, I will tell you, just from my experience, I've had clients fill this out or prospective clients fill this out. I don't really see a lot of success with this form. You got to go through it. And, if you get turned down there, they'll send you a letter saying, we're not going to find that you're worthy of a waiver, but you can ask for a hearing and go in front of the judge. And I've had I've done a couple of those hearings, and again, not getting a lot of positive results with them. Sometimes they'll change the amount, sometimes they'll change the rate of pay, but I don't get the sense they're all that eager in Social Security land to help people get rid of overpayments. That's just my experience. Let's see. Tammy Walker, have you mentioned left closed period case? Often you have cases you never in a situation would apply. Okay, so a closed period, for those who don't know, and thank you, Tammy, for a very good question, would be you'll say, I became disabled on X date, let's say November 3rd, 2021, but I went back to work on, March 15th of 2024. So I just want disability from the time I was out of work. That's called a closed period. Judges like closed period cases because it's not putting the agency on the hook for ongoing benefits. So everything else being equal, two identical cases, one's asking for a closed period, one's asking for ongoing, the closed period is going to get more of the benefit of the doubt. So judges like them because, again, it's a set amount of money and that's it. I would say, and I have clients that will go back to work because they have to go back to work and they have to go for a closed period. So that's usually, or they get better. They legitimately get better and they go back to work. And I can also use that to say they went back to work because they're really motivated to go back to work, and that enhances their credibility. So I would say, maybe 5 to 7% of my cases end up being closed period. But, if I see either A, that the person's gone back to work, which is kind of obvious, or the medical record shows a significant improvement, I will tell my client, look, we're better off going for a closed period, or at least be prepared for that. Sometimes we may not offer that because, the medical evidence is a little, wishy-washy in terms of ongoing disability after a certain date, but I don't necessarily need to give up. I got to be an advocate for my client. I'm not going to give up the past due benefits if the ongoing benefits if we don't have to. But if I sense the judge is kind of leaning that way, or if he suggests it, then I want my client to be prepared for it. So I will tell my client, this may turn into a closed period. A, do you want to just go ahead and make that offer so that we, make the judge's life easier? That's always a good thing. Or B, let's not make the offer, but let's be prepared for that. What do you want to do if the judge throws it out? And that's how we leave it. But closed period can be a good way to get benefits if, let's say the evidence is not quite as strong as you otherwise would like, but you went back to work, and the fact that you went back to work shows your motivation and your credibility there. Okay. I think Dennis asked about the CDR. Again, you can never say never. He wanted to know about a CDR after 57. Never say never, but I wouldn't be overly worried about it. Joel says, hello, everybody. Hello, Joel. Hope you're doing well. Tony, this is a great question. How can anyone afford to live without income waiting for disability payments to kick in? I have no good answer to this, and I get this question all the time. What am I supposed to eat when I'm waiting 18 months, 2 years? There is no answer. The only thing I can tell you is that what I tell my clients is when they're about to apply, they haven't applied yet. I said, number one, if you can keep working, keep working. Number two, you may be going, a year and a half, 2 years with no money coming in. So you want to talk to your mother and father, your brother and sister, your adult children, your close friends, and are they going to be there for you? Are they going to let you couch surf? Are they going to give you a room? Will they defer collecting rent? And I've had to write a number of letters to people that are renting out a room, and they're getting kind of upset that they've been renting out a room and this person's using their electricity and their TV and their kitchen, and there's no money coming in. And I'll write a letter saying, dear so and so, I represent your tenant Joe Smith, and I understand that you've been very gracious in letting him live there, rent free or deferred rent. I want you to know that we're trying our best to get this case processed. I feel very strongly it's a good case and he's going to get paid, and that he feels very strongly he wants to pay you. So I've written those letters. So, I would just say the more prepared you are for that, the better. And I think you raise a really important point, Tony, in that you want to make sure that, you address that with people that are going to be there to help you, because if you don't, the time to find, you don't want to find out, 6 months in, that the person you thought would let you stay there indefinitely is kicking you out, and you don't want to be living in your car. So I think definitely that's something to really be aware of there. Dennis says some judges are unfair. Look, I mean, I think I've showed everybody there's an Atticus. Let me pull that up and you can see it. And we'll just take a quick look at this together. The approval rates here. Okay, this is something. It's still, even though it's from 2022, I still find it very easy to use. But I just want to show it to you. And again, there are some more recent things out there that are less easy to use, but I find this is pretty much okay. So if you go to this website, atticus.com advice, and I'll put the link here in the notes so you can look at it here. Let's see here. Oops. Okay, so if you go over here, oops, I need to do that. Disability judge approval rates can vary drastically. The highest rate was a 97% approval rate, which is quite honestly a little too high. That's going to be, challenged by Social Security. And you got a 10% judge. So imagine you're in an office, you have a hearing coming up, and you have judge 97% in room A, courtroom A, and judge 10% in courtroom B. How upset would you be to get judge 10%? So these judges here, you can see, that are, at the 90s, the 89, 90%, that's a good sign. But then you get down here and you have some of these judges here that are, 12%, 18%, 24%. I've been in front of some of these judges, and some of them are very pleasant, but they're just, this judge here in Atlanta, I've been in front of him. I've actually won a case in front of him. But yeah, it's really upsetting when you just, you draw a bad judge and there's nothing you can do about it. So, you appeal them, and we appeal them. We always appeal those, but, that's just going to take a lot of time up. But yeah, you're right. Some judges are just really, really unfair. I agree with you. Okay, Dwayne says, if I retired at 62 and I qualify to receive back pay, well, realize you get, again, these are great questions, Dwayne. I really appreciate your question. You could get paid 1 year prior to your application date. So if you are, let's say 60 years old and you apply and you allege an onset date, of a year prior to that, actually you want to say 18 months prior to that because there's a 5-month waiting period. But yeah, so you're not going to get 2.5 years. Let's say you retire at 62 and you file for disability and retirement, which you can do. You're not going to get paid back to 59.5 because you only get paid back 1 year from your date of application. So, when you stop working, you should apply for disability is what I would tell you. If you wait till 62 and apply for disability and for early retirement, then your onset date would be, at the time you stop working. So if you stop working at age 62, then that's your onset date. You're not going to get paid back at all because, you're only going to get paid for the time you're not able to work. All right. No Sky says, if you never ask a question, please don't be shy. Yes, I think that's right. Please ask questions. Free legal advice. What could be better than that? Not really legal advice, but, free discussion of your Social Security. What's better than that? So ask away. So the disability combined my ex-wife together. We're not married. She's married to another guy. What am I do? Okay, so I'm not sure, Ricky, are you talking about SSI or SSDI? If they've, when you say you're an ex-wife, do you have a divorce decree? Are you living with her? With SSI, they're going to look at household income. Even if she's not your wife, if she's part of your household and she's earning money that you have access to, that could be an offset. That may be what's going on here. So, again, this might be a question that Greg Brinkley could help with because he's dealt with this sort of stuff. So I would tell you, let me just put his information here again, reach out to Greg and tell him what you just told me and see if he has any thoughts about what you might be able to do. Let's see here. Okay. Why do some lawyers want to get only 40-year-old clients? I think what you're asking is, why do some lawyers only take cases for clients over 40, over 45, or over 50? Honestly, Johnny, it's a numbers game. Statistically, it's really hard to get approved when you're under 50. Not impossible, but much more difficult. And so, we get paid as lawyers in this area 25% of past due benefits if we win. So, if you're taking a bunch of cases, for people who are 25 and 35 years old, you're not going to win as many of them. It's just, unless they've got really, really severe medical problems. So, we only get paid if we win. You're not going to find a lot of lawyers who want to take cases for cases that are a lot more difficult to win. And it may not be that the lawyer doesn't believe you. I've talked to plenty of people that I truly believe they are disabled and they should be approved, but they're 38, 35. And the evidence has got to be, the example I always give would be, if you are age 55, your evidence may need to be here. If you're age, 35, it's got to be way up here. You've got to have just a ton more evidence. It's got to be really just completely unconflicted. I mean, it's got to be really, really strong. So that's why it's just, we can't win as many of those cases, so we're not going to take them. And I can't speak for other lawyers, but that's my take on it. Thank you, Dennis. I really appreciate that. Thank you. Much appreciated. Hey, Jackie, how are you doing? How are you doing, Jackie? Good to see you. Cletus Ellis. How long does it take to back pay? September 21 was awarded. Haven't heard anything. It can take a couple of weeks. It can take a month or two. I think that it's been now, if you got an award on September 21, you haven't gotten your back pay. Now we're almost at the beginning of November. I would call. I think that's too long, in my opinion. And that may be a situation where you call your U.S. senator or representative and ask for help, because that's just taken way, way too long. Let's see here. Okay, Kevin, I'm going to let that. You made a comment here. I'll just leave that in the comments there. I didn't remove anything, so I'm not sure what that's about there. Free case evaluation there. Susie says, hearing in a month. Just spoke to my attorney about pre-hearing briefing and grid. So grids, no help. Did education level, 60-year-old, master's degree. How is that transferable? Okay. First of all, I disagree. I think that if you look at the grid rules, even if you have a master's degree, the grids can still apply. Education does not disqualify you under the grids. Because it's 30 years old, which is perfectly reasonable because it's, not current. And then as far as transferable skills, they're going to look at the jobs. But I think if your attorney said that, your master's degree takes you out of the grids, that's just flat out wrong. Because if let's look, well, you know what? Let's look at the grids and I'll prove it to you. Let's go here to the grids. So let's look at, we'll look at you're 60 years old, so let's look at the light grid here. Give me 1 second here. Share that. We'll see why I'm correct on this, I believe. Okay, so I believe you said that you are 60 years old. Okay, so if you look at here, all these are 55 plus. What does it say? High school grad or more, okay? There's nothing in here about college and anything, okay? High school grad or more, that's the highest level of education that can be seen on a grid. Does not provide for direct entry into skilled work. Semi-skilled or skilled work that is not transferable, you are disabled. It does not say anything about college education. That's not a factor here, just high school grad or more. So it's high school grad or more, high school grad or less. That's all that the grids really talk about. And as far as transferability of skills, let's say that you had a position where you picked up tons of skills. You were doing, let's say I don't even know, let's just say in the medical field that you were a medical doctor. And as a medical doctor, you would have developed the skills to do I'm just making this up, medical assisting or medical transcription or, being a receptionist in a medical office. I mean, that's ridiculous, I know, but let's just use that as our ridiculous example. If you have severe pain, if you have medications that make you drowsy, any skills that you might have had are not going to transfer. That's how I get rid of the transferable skills. Pain, medication side effects, so I completely disagree with your attorney that you cannot apply for the grids because you have a college degree or a master's degree from 30 years ago. Again, look at 202.06. I use that all the time for college educated people. So I would just respectfully tell your attorney, you are wrong, in my opinion, at least that you can say Ginsberg said you're wrong. Okay. All right. Is the benefit amount based on zip code? No. No. It's based on your earnings record. So if you've paid into the system, there's a calculation that's done, something called your PIA, primary insurance amount, and that's what determines how much you get, not where you live. Okay. Okay. Vince is talking to Tony about applying for SNAP benefits and Medicaid was approved. And so again, just Vince, there's a bunch of forms. That's correct. Justin says, can I request a copy of the reconsideration appeal brief my attorney just showed up on my SSI account? Well, it's not a brief. It's really just a reconsideration appeal and medical report. If your attorney did it for you, he should have made a copy or she should have made a copy. I always make a copy, put it in our client portal. My clients can then go and download it. But, that's the only way that I'm aware of to get it, because until you have a hearing requested, right now, your attorney will have access to sections E and F of the exhibit file, which is the medical development and medical records. But the reconsideration appeal, that's in section, I think, B, or D or something. So you're not going to see that until the hearing. So if your attorney did it, he or she should be able to provide you a copy of it. Okay. Let's see here. Well, my disability payment come on Halloween, so holiday didn't come today. I don't think Halloween is a federal holiday. The mail comes on Halloween. So it just depends on the day you're supposed to get it. But Halloween is not going to prevent you from getting your disability payment because it's not a federal holiday that the government takes off, at least not yet. Okay, Everett says, I'm a 42-year-old disabled veteran rate at 100%. Is it hard to get SSDI? I'm currently working full-time and going to part-time so I can stay under 1550. I would say the 42-year-old is the hard part, because your 42-year-old, the 100% VA disabled is not going to be binding on Social Security. It's going to get you to the front of the line, but it's not going to be binding. So that's not going to help you medically. Yeah, it's hard. And again, if you're working full-time and you're going to part-time, and you say, so you can stay under 1550, realize what you're saying there, that you're working over SGA and that you're going to change your hours to get under SGA. You're not saying that you can't, you're saying because you want to. The medical record has got to support why you're only able to earn $1,400 a month. So suppressing your income, there's a concept called income suppression, that if Social Security senses that's what you're doing, the only reason you went to fewer hours is so you'd qualify for Social Security. That's not going to really enhance your credibility. So just be aware of that. And being 42 is going to make it really hard. My point is simply this. Unless you have some significant medical problem that would really prevent you from working, if you can work and earn more than SGA, keep working. That's a much better bet, I think. When did it start? How did it get to the person? One person determine if you live or die literally. It's something that Congress passed, I think, in the 60s, and realized that Social Security is an agency. It's part of the executive branch. And this is something that, people have asked me about this before. There's this whole Chevron doctrine you maybe have heard of, that basically says that the courts would give deference to the procedure and decisions of an agency, and the case came along and said, no, Congress has got to do that. But we haven't seen any major changes at this point. Social Security kind of developed organically. You've got a bunch of bureaucrats that made up a bunch of rules. I don't know who actually came up with sort of the big picture thing. If I had to guess, I would tell you that, when Congress, charged the agency with coming up with a procedure for SSDI, they were basically told, the people writing the procedure, don't make it easy. Make it where the person has really got to prove they are disabled, um, and that it's not real easy to do. We don't want to encourage people that it can work to not work. And we want to go further. And again, Spencer Bishens is a gentleman that I interviewed on my podcast maybe last year. And Spencer used to work for Social Security. Maybe I'll try to get him on at some point. He thinks that, he used to work there, and he's like, all these delays, all this stuff is intentional. He's very cynical about it because they want you to give up. They want people to die waiting. I mean, maybe that's a little extreme, but they want people to, have to just go through everything they own, because they don't want people on disability benefits. I've said this before many times. There's no lobby to Congress for people on disability. There's a AARP for people on retirement Social Security, but there's nothing like that for disabled people. And so, you're not a voting bloc. So Congress, they see this as a money they can spend elsewhere. And so that's why they make it so hard. And then you've got, federal agency bloat. That's going to happen. They just have people that need to justify their salaries. So they keep coming up with more procedures, more hoops to jump through. And this is what we got. We got this, just really big bureaucratic mess that is, and you don't really have any curbs or any kind of controls on judges. I mean, again, I showed you a few minutes ago, you have a judge that approves 97%, a judge that approves 10%. Anybody coming up with a system that's supposed to be fair would say you can't have that. There should be some way to look at judges that, if we think that judges ought to be approving based on some analysis of cases that, right now, let's say around 50% of cases at hearings should be approved, then if you're more than one or two standard deviations from that, we're going to look at it. Well, they don't have that. So yet, at least. So you have this wide disparity of judges. And, so that's how it's just, I think it just sort of started out with kind of a general make it difficult, and it kind of evolved by people just coming up with more reasons to justify their salary. So, Ricky, I think you were asking about the ex-wife and so forth. The SSI's income and resource, that's why they're doing that. They are looking at your household income and resource. Okay, Michael Kingsley. Does an individual's SSDI payment increase if he or she has a dependent under the age of 18? If so, is it calculated? Yes, it will. It's based on your PIA amount, and generally an auxiliary is going to be around, I'm just being a very general, 25% of your benefit. They don't take out 25% of yours. They're saying, let's say you're getting $1,000, your auxiliary is going to get $250. So it's generally going to be about 25, an amount equal to 25% of your benefit is generally what you get. If you have 7 children, though, it's going to be less, because at the most it can be, there's something called a family max. And so you can't be over the family max, but if you have 2, maybe 3 kids under 18, they'll each get, the 25%. And again, I haven't really gone through those calculations because there's no reason for me to go through them. I just want to make sure that my clients' auxiliaries are paid. And by the way, somebody asked me this today, if I'm representing somebody and their auxiliaries get paid, I get 25% of the past due for all the people involved in it, since it's that one case. But again, it's capped. Right now, $7,200. In December, it goes to $9,200. But, I've had situations where my clients' past due benefits, let's say were, I don't know, pick a number, $16,000. And so, I get $4,000 as a fee based on my client, but the auxiliaries might add another $7,000 or $8,000 to that, and I would get 25% of that too, up until the cap. That's how that works. But the payment does go up if you have auxiliaries, and it will go down, or the auxiliaries will drop off when they're no longer dependents. So your pay, actually, let me be more accurate. Your payment does not increase. You have auxiliaries that get their own payments. So you may be the guardian, a parent or guardian. Your payment itself does not increase, but there will be another payment to another party, the auxiliary. And again, if you are the parent or guardian, you'll be the person in control of that. The judge up next, Judge Breach has a 62% approval rating, 58 seventh grade education, second attempt, alcohol and abuse about. Well, 62% is good. That's a really good thing. 58 is a really good thing. Seventh grade education is a really good thing. Now the question is, the alcohol use, is that over? If you are clean and sober and there's evidence of that, that will be found to be not a contributing factor. And assuming you have other medical evidence that would support, let's say either the grid rule or a functional capacity argument, you got a good case, I think. But again, I don't know what the underlying medical issue is, but if the alcohol abuse was in the past and there's evidence that you're no longer actively using it or it's not a material factor, then you should be okay. Hey, Tara, how are you doing? Again, one of my clients. But I appreciate you tuning in and good to hear from you. Thank you. Michelle, okay, asked me a question a couple weeks ago about non-medical review, and you were right. Well, good. I'm glad I was right. I was good on reconsideration with attorney. Oh, awesome. That's awesome. Thank you, Michelle. I'm very glad to hear that. And I'm glad, recon is hard to win at. Now, I will tell you, there's been some talk in the NOSCR listserv. I'm not verifying. I'm just telling what I'm hearing. What people are talking about is that Social Security is trying to close out a lot of cases before the fee increase changes. I'm not sure why they would really care, but there seems to be some people who think that Social Security is trying to get cases approved at initial and recon, before the end of November. If that's so, cool, that's great. I mean, the more people that get approved early, the better. My feeling, and I think most of my colleagues feel like, if you can get a case approved at initial and you get $1,000 or $500, that's fine. Doesn't bother me in the slightest. People who sometimes I've seen people say this to me, and I find it a little bit insulting, although I kind of understand their position. You're just intentionally delaying this so you can get to a hearing and make more money. Well, the reason that's absolutely not true is that chart I showed you before. You have a really good case, but you draw a judge 10%. You're not going to win. I'm not getting paid. So, there's just no reason I would want to delay anything. I want to get cases approved and turned over, and I can move on to the next case with a happy client who's going to write a positive review. I'd much rather win early. And I've got, I'd say 15% of our cases get approved in initial recon, sometimes more. Some months more. We try to get good cases, but yeah, if I get approved early, absolutely. So I'm glad, Michelle, that this was helpful to you. Please let me put the review thing on here. So if you found it helpful, please leave me a review. That would be great. But I'm glad for you, and I'm glad the system worked. You don't have to wait forever. So that's cool. Johnny is a friend who's 26, never worked. Your friend could apply for SSI. And again, SSI is means tested, Johnny, which means that if he has any household income, he's married, has a spouse, has any assets, cash in the bank, that's going to offset it. It's going to be really hard at 26. I'm not going to lie to you. You got to have severe, you got to be almost non-functional when at 26. It's just really, really hard. Really, really hard. Okay, Breach, thank you very much. Please let us know. If I hope you don't get denied, but if you do, call us. Why does Florida take so long for reconsideration? The only thing I can think is that realize that the state agencies, Social Security contracts with the state you live in. They have an agency in the state to adjudicate or evaluate claims. And these are state employees. Their Social Security refunds the money or pays the money over their salaries and the cost of doing business to the state, but the state agency actually employs these people. It may be that Florida does not have enough people manning the desk at the state agency, and that's probably what the issue is. So this is something that, Florida legislature needs to, increase the hiring to have more people. But again, no lobby, no money. So that's why. But that's why, and also could be the number of people applying. But I think it's really more a function of resources. Okay. Okay. Hartford making paid somebody for SSDI service. I dropped them for denial and no help. Switched my own lawyer and Hartford settled of them $7,500 fee. That does not make sense to me. I've never had a situation where, well, first of all, let's back up. Before any provider, an attorney or non-attorney rep can get paid anything, they have to apply, get Social Security to authorize it. So no one's getting paid anything unless Social Security authorizes it. So if basically, you have to repay Hartford whatever you got paid in terms of the lump sum. But if your attorney got paid $7,200, then you don't pay that part of it back. That just does not sound right to me at all. That they would say you got to pay non-attorney rep, money that you did not receive. So you might want to just double check on that. I've never seen that. That just sounds really implausible. I would actually ask your attorney to make some calls for you. You've got an attorney, and the non-attorney rep. No, well, let's look this way. The non-attorney, and when I'm thinking about this, it makes no sense. If your attorney did not get the non-attorney rep to withdraw and waive fees, he didn't get paid. So your attorney needs to find, if your attorney got paid, then that means the other non-attorney rep withdrew and waived fees. If that's the case, no fee owed. So this makes no sense. I would talk to your attorney about it. Okay. Ricky says we live the same address and husband says, again, Ricky, I don't want to get into details because now we're getting into the specifics of your case. I think I would definitely reach out to Greg Brinkley on this. This may simply be a situation, and let's just leave it at this, where Social Security does not have the full picture of your assets, your income, your resources, and the help you're getting. Okay. Yeah, again, JJ, you talk to your attorney. That's your attorney needs to get this straightened out. Deb, yeah, Deb's correct, and that's what I said before. Your SSI this is for dependents. Your SSDI does not increase, but your dependents will receive an auxiliary benefit. I think it's probably going to be 25%, not half, is my understanding. But yeah, your benefit does not increase, but you do have an auxiliary that will get paid. Yes. Can you apply to regular Social Security at 62 and apply for disability or collecting? Yes, you can. And what happens is if you win, you'll get the difference between the early retirement and the full retirement, because SSDI is roughly equal to your full retirement. So that means that if you are applying for regular Social Security, you start getting, let's say, $1,300 a month, and you win, they'll bump it up to $1,700 or $1,800, whatever your full retirement amount would be. So yeah, that will happen. Two caveats though. Number one, if you lose disability, which is, you're 62 and you've got something that's probably not going to happen, but if you lose, you're stuck at that lower figures. You're not going to ever get to full retirement amount unless you go back to work or something like that. But so you're basically stuck. So that's one danger, because you're going to be, and you're giving the government a 25% discount if you take it at 62. So that's one point. The second point is you may have trouble finding a lawyer, because in fact, I had this happen today. Somebody called my Madeline, one of my call screeners, and basically has a situation where he is applying for early retirement. His benefit is very low. It's like $500. And he wants to apply for disability. Okay. He applies for disability. Well, his full retirement would be like $750. So the difference between $500 and $750 is $250 a month. Well, you look at that, and I get 25% of past due benefits. Let's say that it took, let's just make it, 18 months, and because there's a 5-month waiting period. Let's just say 18 months times $250. That's $4,500. Times 0.25%. That's $1,125. So the question is, am I going to take a case on a contingency where I could maybe earn $1,125 when I've got other cases. Somebody is applied and there's no early retirement, and I may generate $4,000, $5,000. It's just hard. I mean, I don't generally take a case just because it's just my cost of doing business is more than $1,125 for 2 years. I'm working these cases many times for 2 years. I've got to pay, Jen. I've got to pay Matt. I've got to pay my staff. So I'm just, it's the same amount of work for $1,125 as it is for 7,000. So, I'm not going to take cases unless the early retirement amount is say $1,500, $1,600. That will at least give me a $500 or $600 spread I can work with, and that makes sense for me economically. So I would just point out that if you have a early retirement and you're taking it, it may be more difficult to get an attorney. Not impossible, and some attorneys would say $1,125, I'll take it. But it's probably not something I would take because it's just not enough. But the more the retirement is, the higher the spread's going to be, the more likely I would take it, because those cases a lot of times are winners. So I don't want to win the case, spend a year and a half, 2 years on it and lose money on it, even if I win the case. Is my point. Okay. Is it true? I don't know. Honestly, I do not know. It's just beyond what I deal with. I don't know. If anybody knows, does anybody know whether they're changing the payment date based on the day of the month you were born? Day of the month you were born. I don't know. It could be. I just don't know. Breach says, recently 20. Okay. Received a letter if they would notify me 20 days before they. Yeah, they would typically do that. They will send you a letter that will tell you that. It usually revised notice of hearing. So just, again, it's not going to make a big difference to you in terms of how you prepare, but most cases there will be a vocational witness. Okay, Christina is 57 filing for SSDI. Well, Christina, I don't know what your underlying medical condition is, but it's always helpful to be over 55. Makes it a lot easier. So if you have a physical issue, look at the grids. Go to gridrules.net, my website, gridrules, G-R-I-D, grid. I think Jen posted it earlier, but gridrules.net, and look. And you can look earlier. I did a screenshot, but look at that if it's physical. But 57. Even if you could do light work, you're very possibly going to win. Do I have a video to see the process of document reconsideration? I don't know if I've got anything on the YouTube channel about recon specifically. It's really a pretty simple process. I may have something out there, but basically recon it's going back to the same people that denied you before. They asked for an updated medical report. Has anything changed? And that's really all it is. And they're just looking at it, taking another look. And statistically, right now about 35% of initial applications are approved. Recon is maybe 15%. Of those who appeal, only 15% get approved at recon. Then of those who appeal again, about 50% approved at hearing. Recon is the lowest approval percentage of anything at this administrative process. It's really kind of a waste of time. There had been some talk years ago about doing away with it, and they decided not to. It delays the process, and if you believe what Spencer Bishens tells you, it's done to just delay the process. There's no reason to have recon, honestly. Okay, Christina says, under ex-husband's record, delaying filing for either early retirement or full retirement for negative outcome. Okay, so you're 57 filing for SSDI under ex-husband's record, delaying filing early retirement or full retirement. Again, if you win disability, then basically you stay on disability till full retirement age, and then they'll move it over to whatever is higher. Now, there are claiming strategies for Social Security that are beyond what I do. And there are people out there who, talk about the claiming strategies for retirement Social Security. I just deal with disability. But if you're applying for disability on your ex-husband's record, and I'm not sure how you would do that. If your ex-husband is deceased, you could possibly do that. But again, that I don't know that you can claim it your ex-husband's record for disability if he's alive. So I think you may want to double check into that. I think you have to apply into your own record. You can possibly use somebody else's earnings record if you're filing for retirement, I believe, but not under disability. So you might want to double check that. Oh, no problem. That's not a problem, Christina. Not a problem at all. I mean, these are very interesting questions, and if I don't know, I'm going to tell you I don't know. I don't really know about retirement Social Security claiming policy, claiming strategies. Just I don't do it, so I don't guess. Okay, another Christina. Please do not forget to like. Yes, thank you very much. Okay, B-name 86 was found to have severe compression of my popliteal artery whenever I've been my knee, Hartman syndrome, and small fiber neuropathy in one extremity. I don't know how old you are, so that's going to make a difference as to whether the grids could apply about your walking and standing. I think you could make an argument that if you cannot bend your knee, means you're not going to be able to sit very long, and neuropathy, those are significant problems. And I think that, the degree of severity is something your doctor is going to have to comment on, but I could certainly see those conditions being significant enough to disable you from any kind of work if your doctor supports you. If you're 25 years old, it can be a lot harder than if you were 55 years old, however. But I think that the conditions themselves are inherently serious. It's just, what does the medical evidence show in terms of the severity? All right, Melinda is 54 years old. And she's okay. And again, 54 years old is very possible you met the grid rule. Okay. Yeah, 38. That's the problem. You're 38. You've got a lot of stuff going on. So it doesn't mean you can't win. It just means you're going to need to have really, really strong medical support from your doctors. But being 38 is going to make it hard because they just don't want to pay people under 50. That's just the reality of it. Johnny, I don't want to even comment, but I think SSI has different rules in terms of part-time work. I just don't know because I don't really do a lot of SSI. Here again, I would reach out to Greg Brinkley. I think he could probably tell you better than me. I don't know, and I don't want to guess. I'm sorry. Can you apply for disability for education? I guess what Rob would be asking is, can you apply for disability because you have, very, very low education? There is, in the listings, there is something that talks about, very low IQ. That could be a listing level issue. Obviously, if you have a physical problem in addition to being, very limited education, like I'm looking at the grid now, if you're illiterate or unable to communicate in English and you have unskilled work, that would grid you out. So education has a place. Lack of education is more helpful than having a higher education is hurtful. So yeah, but unless you have an intellectual disability, having, let's say, a 7th grade education is not inherently disabling. There are jobs that you can do. Although I would say, to be fair, that fewer and fewer of those jobs are out there that you could do with less than let's say you dropped out of school in 7th grade. But there are jobs you could do, so that alone is not going to be enough. Okay. Let's see here. We got about 20 minutes to go, by the way. Chords of gratitude. What happens if VA radiology, misread your MRI? I've had a pituitary issue for 27 years. Now they say it's normal. Well, one thing I've done is I've asked another radiologist to read a client's MRI. So, maybe that's something to look into is, can you find another radiologist to read it? Or ask the VA to have another radiologist there to read it. Or the other thing you could do is, there are, not that you want to be having multiple MRIs, but a lot of, many cities have very inexpensive MRI clinics, $350, $400, you get an MRI done. But first thing I would do is I would try to find another radiologist. Probably, sorry about that. I played tennis today. My wife ran me around the court, so I'm a little tired. Anyway, I would try to find another radiologist, maybe a couple $100 to read the MRI and maybe get a different, report, and that's something you could use in the disability case. Yeah. Let's put this other thing back on here. Sorry about that. I'm just changing the, okay. Okay, I know that, a B name is the person with the significant medical problems in his 30s. Yeah, I mean, I think that these are things that would give you a leg up. But again, your age is an important factor. If you have really strong medical support, you could certainly win. Okay, yes. Yeah, so Deb is responding to T-Cash, asking about are they changing the date for payment, and yes, it could happen. Luca's been here before. Luca Brasi from The Godfather. Do most recons say? Yeah, most of them do. Right now, 85% are turned down. So, Jen, thank you very much. I appreciate that. Well, thank you, Jen. I appreciate that. Jen works for me, so take her comments with a grain of salt, but I still appreciate it. Jen, yes, we do work in every state because hearings are done by phone or video. So I have a case tomorrow in Chicago, out of Chicago. I'm in Atlanta, and I'll be dressed in a t-shirt and shorts doing it because I'm in my home office, right from where you see me sitting here right now. And I've got another one on Friday from California. So, or maybe not, I think the one tomorrow, one on Friday is in Georgia. What we do, by the way, is we can tell Social Security when to schedule how many days we're available. So typically there are 20 work days in a month, and so there are 10 regions. And so I'll say I'm available 2 days, 2 days, 2 days. And if I've got no cases in a particular region, then I'll basically, put no days on that. But yeah, that's, we filed that. In fact, I got to do it tomorrow. Okay. Do lumbar MRIs change? They can. I mean, I think that there are times when I've seen, herniated discs get absorbed. Sometimes they get worse, sometimes they get better. Usually an MRI within a year or two is going to be pretty current, but beyond a couple of years, you might want another one. Now, taking an MRI, there's always risk. I mean, there's radiation, there could be dye, so yeah, it can be risky. Not a huge risk, but you don't want to be having them every 15 minutes. So, but yeah, they can change, but usually after, I would say more so after, a couple of years. I think anything more recent than that's probably okay. Randy, okay. Yeah, okay. Getting a current MRI in the back, good. That will be helpful because I think you want to get that current MRI. Absolutely. Can you apply for graduate life school diploma in high school? Yes, absolutely. And certainly, the question is, can you make an argument that is something less than a full high school diploma? So again, under the grid rules, that might be less than a high school education, especially if you had special education classes. That can help your case. So yeah, that you can certainly apply, and that can actually help you. Cords, my pleasure. Thank you. RDs, 55, chronic bladder, pelvic pain due to surgeries, frequent urination issues, sitting, standing, pulmonary stenosis. Yeah, you've got a good case. I mean, I think, again, I haven't looked at I preface this by saying, based on what you're telling me, it's a good case. I haven't looked at the medical records, but based on what you're saying here, it sounds pretty good. I mean, 55-year-old with all these problems, the urination issues, I win a lot of cases on that. You've got, foraminal stenosis, which is basically a narrowing of the space in your spine. I think that sounds pretty good to me, I think. All right, let's go back here for a second. Recon, somebody says, like SA says, what is recon? Recon stands for reconsideration. And that's basically where Social Security has Social Security is revisiting your case. They've denied you once, and they're now looking at it again. Let's see over here. Okay, let me just look at this. All right, so there are a couple of the questions that we've got. Oops, that's the wrong place I'm looking at. Give me 1 second here. questions for live stream. Okay, I've got a few more questions that were asked by email. So let me go to some of those. I'm not going to post them because I guess I can post them, but we'll just leave it. I'll just read them out to you. All right, somebody asked me, can I get SSI and SSDI at the same time? The answer is yes, you can. It's pretty rare, but you can. Generally speaking, again, SSI is a means-tested program, meaning that if you have assets or income, it offsets it. And SSDI almost always offsets SSI because SSI, the maximum is like $1,000 a month. Most SSDI is going to be more than that. But let's say your SSDI was $700 a month and you qualified for the maximum SSI, you would get, a check for $300 from SSI and $700 from SSDI. That's one way to do it. Second way it can happen would be during the 5-month waiting period. If that applies, then if you're eligible for SSI, you get SSI for 5 months and then SSDI kicks in. But generally when SSDI kicks in, it offsets SSI. So most people are going to get the SSDI amount, but every once in a while I see somebody who's getting both. Realize the SSI, because it's means tested, it can go away very quickly if you start working or if you gain any sort of assets. But yeah, it can happen. All right. If somebody says, I have a question. I'm working full-time right now, but I need my employer's insurance. Been through the stage of getting denied because I didn't have the medical consent form in the SSA. So when you file for disability, they send you a form called the 827. And the 827 is a medical release form. And if you don't send it back to them, then they'll administratively dismiss your case. If you drop, but he's working full-time. If I drop to part-time, when you send, and let's see. So really this question is, how long would he have to be part-time before he can apply for disability? As soon as you go below SGA, you can apply for disability. But as I told the other gentleman who had asked this question before, you want to be real careful about not appearing to be engaged in what is called income suppression. In other words, the Social Security senses that the only reason your hours got reduced was because you wanted to qualify for disability. That's going to make you not very credible. The reason why you should qualify for disability is because you got medical problems that prevent you from working. If you have the capacity to work, okay, and the reason you reduced your hours was to qualify for SSDI, that's not really reflective of your capacity. And so the medical evidence needs to show that the reason you reduced your hours was because you had to, not because you wanted to. So that's where, but the specific answer to the question is, as soon as you go to below SGA, you can apply immediately. Okay. What about, this is another question. What about people who are over 50 with mental disabilities when it comes to renewing, when it comes to a CDR? Again, my standard reply would be that if you're over 50, the odds of a CDR are lower. If you're over 55, even lower, whether it's physical or mental. There is some discussion that mental health cases are more likely to be reviewed simply because mental health cases are approved based on what you've reported to your doctor. There's no objective test. You don't take an MRI to see depression. And again, in Congress, and Congress holds the purse strings, in Congress, there is a narrative out there that says that anybody people got on disability for years claiming depression are all fraud. So, is it possible Social Security is going to pay more attention to those? Yes, it is certainly possible. But I think being over 50 really, really helps. All right, so here's another question. Nini says, I got denied at the hearing. My attorney wants to go to the appeals council. I think it's worth it. Appeals council is only going to reverse or remand 10% of the time. Usually the next step is federal court. That's where you're going to see most of the results. I would exhaust your administrative remedies. There's no reason not to, but you're probably not going to win at the appeals council. I would just say that. Okay, let's go back here. Again, I've got 10 more minutes here. Age 52, doctor says sedentary work only, high school education, last 5 years as a truck driver, Can the grid apply? Yes, the grids would apply in that situation, assuming no transferable skills. Okay, I got a couple more questions coming in. Let me try to get to these. I can save these other ones for next week. Um, um, I had a herniated disc, arthritis, lower back, facial paralysis, hard speaking. I'm almost 55. You know, herniated, it really depends, Salim, on, what the medical evidence shows in terms of your functioning. Facial paralysis is going to eliminate jobs when you can't speak that require interaction with the public or a lot of verbalization. So that's going to eliminate entire categories of jobs. A herniated disc, arthritis in the lower back, how bad is it? Is it a mild herniation, a severe herniation? So those are the questions I would ask. But being closer to 55, if you waited till 55, it's going to be easier. But it's going to take a year and a half, 2 years. So maybe there's no reason to wait. But I think the real question is, how severe is the disc herniation? Because the facial paralysis and the trouble speaking, assuming that's permanent, that's going to eliminate a chunk of jobs, but not every job. Okay. Chan Tet says, I submitted my Recon 8.8. Dr. Ragnar, to how many months we get the answer. I would tell you 8-10 months, typical at Recon, depending on the state. That's just a guess. How can I help my lawyer before next week, and what should I ask him? I would ask your lawyer to, we talked about this at the very beginning, to go over the procedure. What's going to happen? What questions am I going to get asked? If your lawyer knows the judge or been in front of that judge before or can research the judge, what can he tell you? Does the judge ask a lot of questions? Is the judge pleasant? Is he aggressive? Whatever, So I think that, you want to do that research. But I think as a minimum, your lawyer should walk you through the process of things you're definitely going to be asked. You're definitely going to be asked, are you recording the hearing? You're definitely going to be asked, do you agree to a telephone hearing? You're definitely going to be asked, are you by yourself in a private location? You're definitely going to be asked about your past work. You're definitely going to be asked in some way, shape, or form, why you're not able to, a quick explanation why you can't work specifically. If it's physical, how long can you sit, stand, walk, kneel, crouch, stoop, stairs, ladder, scaffolds? Just the questions that are going to come up, and practice them. And I will tell you, when I practice with my clients, sometimes I had a case recently where I was talking to my client the other day, and she tended to ramble. She's got adult ADD or ADHD, and she tends to ramble. And I kept saying, okay, let's bring it back down. Let's not go into, your ex-husband coming over to, clean the chicken coop, which is what we're talking about. That's not, what do you do? I don't care about your ex-husband. I want to know what you do in terms of caring for your dogs and cats. Who has to lift how big is the sack of food? Who has to lift it? But don't give me the whole story about your ex-husband coming over and that you never got divorced, and you got divorced, but you still, have a good relationship. And that's not relevant to Social Security. What's relevant to Social Security is what you can physically do or mentally do in terms of a job. Okay? So that's the questions you want to ask your lawyer to go over with you, Adam. Okay. If you retire or quit at 61 and apply for SSDI, can you apply for SSI at 62 only? Well, you wouldn't apply for SSI after applying for SSDI. That doesn't make any sense. You can get your early retirement. So if you apply for SSDI at 61, then when you hit 62, apply for early retirement. Yes, you can do that. And that way you get money coming in right away. Yes, you can do that. You are welcome, Breach, and I wish you the best of luck at your hearing. Okay, we got about 5 more minutes here. Chen, my pleasure. Thank you for tuning in. I really appreciate that. Michelle wrote me and said, I moved to Mexico 20 months ago, submitted SSDI claim in July of 22, hearing is set for December 17th. No lawyer wants to represent you because I'm too young to win. I'm 32, live outside the U.S. What are the chances to win without a lawyer? The fact that you're outside the U.S. is not a big deal. I had a case out of Vietnam earlier this year. We won. I've had cases of people in foreign countries. The 32 is the problem. It's just, somebody asked this before, or was talking about this before. They just don't want to pay people under 50. And at 32, you got to have overwhelming medical evidence. And if you move to Mexico, are you getting treatment? Do you have medical records? Is it in Spanish? Is it, these are all practical matters. That's the problem. It's going to be hard to find a lawyer. And I understand it's just because, the odds of winning are just not great. So I just, I hate to be the bearer of bad news, but I just want you to understand why. Okay. If you're receiving SSD and start drawing retirement at 65, does it stay as SSD or just consider regular? They convert you over because SSDI and retirement, full retirement, are basically the same amount of money. So at full retirement, they convert you over is what they do. And that's how that works. So yeah, they will convert you over. Automatically, you don't really need to do anything. So yeah, it's, Social Security can be a little confusing, and I always tell people, generally speaking, stay on disability as long as you can, and that way, when they convert you over, you'll get the highest retirement amount. But it can be a challenge. I mean, Social Security. Look, I've done this for 30-something years, and it is a challenge. And there's always, they're just always looking for ways to make it more difficult. They do not want the trust fund to be exhausted, and you keep hearing it's sometime in the 2030s. We're in 2024, so we're looking at 10 years, and Congress keeps kicking it down the road, and at some point the piper's got to be paid. And I don't know what's going to happen obviously in the election coming up next week. Trump is talking about reducing the number of what is he talking about doing? Eliminating tips and things like that. I think Kamala Harris said the same thing. So I don't know. They're talking about, making it, the trust fund even less solvent. And they're going to have to do something because people aren't going to stand for automatic cuts. But, Congress tends to want to not do anything till they have to. And then, so my guess would be, if the trust fund's running out of money, on March 15th of 2035, March 10th of 2035 is when they're going to look at it. Because it's really, people get really upset about this. I mean, if you're a retiree, you don't want anybody touching your Social Security. If you're applying for disability, they change the rules in the middle of the game, you're not going to be real happy. I was looking actually at there was something that was done about 10 years ago, a report that was some suggestions about changing it, which some of them, make some sense, but will our political leaders have the courage to do it, Yeah, Congress, I was up there, like I said, last week. Maybe I'll get some pictures of, us at the Capitol. We just were walking around and just in the background. And yeah, it's a beautiful city. Washington, D.C. is a beautiful city, wide streets and boulevards. And, everything is clean, and it's pristine. You got these clowns in Congress who just are, like to hear themselves talk and, don't have the courage to make difficult decisions. And they're so busy yelling at each other that, we kind of get left in the dust. So, it's not an easy situation, and the deficit is really bad. I mean, look, we still have a great country. We still have some, a lot of things to be thankful for, but I think in many situations our leadership is not ideal, So, okay, so let me go ahead. We're going to go ahead and end this. It's about not quite 2 hours. I think I'm 1 hour and 58 minutes. So we're pretty close to it. So I'm going to go ahead and somebody said something here about commercial representative specs. Economists, not lawyers. Yeah, I mean, of course, you know what? The point here is we need economists, not lawyers. And I think, there probably are too many lawyers in Congress. Economists don't agree on anything anyway. I mean, you may have 5 economists, they all have different things. Economics is not an exact science. And you have some economists who are supply-siders and some who are Keynesian. So even having economists isn't going to do anything necessarily. What you need is people with common sense that have courage. And that's what we seem to be lacking. Not all of them, but I think many of them they want to hear themselves talk. So, it is what it is. Nothing, no, I get you. Now, look, there are too many lawyers. I mean, lawyers, can sometimes make simple things really complicated. But on the other hand, they can make complicated things simple, which is what I try to do. So, okay. All right. So I think that'll be enough for today. I appreciate everybody's attendance here. We had a a bunch of people that watched. I really appreciate that. And again, if you did find this helpful, let me put this on one more time to please give me a nice review. Just, just type in Jonathan Ginsberg or Ginsberg Law Offices into Google. It'll take you to my Google, the page, and you can leave a review. Much appreciated. Go to Avvo, AVVO. I think I've got a link to that someplace here, if I'm not mistaken. I don't think I've got it here. I'll have to get one. But you can just go to jonathanginsberg.com and review me there. But yeah, any place you can leave a positive review, please do that. And again, do like and subscribe. I really, I have a good time with this, and I've had some really great questions. So keep them coming, and I will see everybody next week. Have a safe Halloween. If you're out trick-or-treating, if you have kids out trick-or-treating, just be, don't try not to drive. Be real safe. Be careful about any candy that you or your loved ones ingest. Don't eat too much candy. And although I should not be talking about that because I'm not really good about that. But have a great Halloween, and then I hope everybody survives. I think we have the election next week. Is that right? So next Wednesday we may be having a very interesting discussion. So anyway, hope everybody has a great rest of your week and weekend, and I will see you next week. Y'all take care now. Bye-bye.